Right, well, my name is Selwyn. I'm a well-known bridge player and snooker player, and in my spare time I write textbooks on law. I think there are two important things. First of all, the reader has got to be able to understand the law. Most of the people are going into practice and they have to apply the law, and people want to come to them asking them for advice. So they want to know what the law is. Fine. And this is what I try to do. I don't go into massive sociological explanations or interpretations of the law. I just try to state the law as it is. I rarely speculate into what the law might be, because who knows what the courts are going to do and what the courts are going to say about this sort of thing. So I think you've got to be accurate. The second thing is even more important as far as I am concerned. You've got to be up to date. There is nothing that grieves me more than if I go into a bookshop or a library and I look at employment law books on the shelves and I see books which were written 3, 4, 5, 6 years ago, and I think, well, that is a menace. It's useless. It's hopeless. Get rid of them. Of course they won't, but this is it. And this is why I try to be, and I've been very fortunate in that every time there's been a major change in the law, I've just managed to get my new edition out in time to catch this change. So I've been very lucky as far as that's concerned. But that's crucial.
So the currency of the book, the content, is a big key to having it.
Absolutely. But it's got to be bang up to date as far as possible. You're never going to be totally up to date. There is never a right time to write a book on employment law. All you can do is, you write it and then hopefully get a new edition out within a couple of years if the book goes. Yeah. It's impossible to answer that question. There's been so many changes. I would put it this way, in 3 areas in particular. First of all, you get statutes, Acts of Parliament. Now, when you think of it, we had the Sex Discrimination Act, Race Relations Act, Disability Discrimination Act, Health Safety at Work Act, and so on. I mean, just massive stuff there. Then we had regulations, which are those things which are passed under the authority of an Act of Parliament, which deal with age and sexual orientation and religion, belief, and so on. Massive stuff in there. And then thirdly, you get the case law, decisions of the courts, particularly of what is now the Supreme Court, but also of the European Court of Justice, which overrides everybody. So in those 3 areas, you have change taking place all the time. You can pick whichever one you want.
Yeah. Okay. So if we're looking back at the first edition of the book as it came out, how's the book evolved from that first edition to today?
Well, you can see the difference, first of all, in terms of the size. I mean, that's the first edition. I think it's 7 chapters. This is the 15th edition. It's now 23 chapters plus appendices, where you can compare the two. And that gives you an indication. And do remember, this book is a simple version of the law. If you want to really go into it stuff, can you get these on here? 6 volumes of Harvard's Industrial Relation. I mean, that's an example of what the law is all about.
Oh, okay.
Over the years, there's been a lot of statutory provisions on discrimination, on race, sex, religion, belief, marriage, pregnancy, sexual orientation, all those sort of things. Because it's been done in a higgledy-piggledy way, they've not coincided with each other. So you get oddities from one particular statute or provision as opposed to another. It's all, and the courts have had to struggle with this sort of, differences which occur over what is basically a similar problem, namely discrimination in employment. So what this Act does is try to unify all these concepts and bring them all under one umbrella, so they're all dealt with under the same conceptual analysis, right? I'll give you a couple of examples. I mean, take for example, associative discrimination, what we call associative discrimination. This is where you discriminate not against a person, for example, who is disabled, but a person who is associated with a disabled person. For example, a woman who is a carer for a disabled husband, and she's treated badly. Now, under the old law, that didn't there was no discrimination because she wasn't discriminated against on grounds of disability. It was the husband who was disabled. What the new law does is say, yeah, if you're associated with a person who is discriminated against, then that is discrimination against you. Because it does it simply, you see. The old law of discrimination would say things like, you discriminated because of race or sex, whatever it was. What this law, new law, says, on grounds of. So if the grounds are the protected characteristic, the disability or race, whatever it is, then that can be associative discrimination. Also, for example, you get what we call deterred discrimination. This is where a person is deterred from applying for a job because he knows he won't get it because of a characteristic which he has, maybe sex or race. You might, for example, know that that employer does not employ Muslims or women or whatever. Well, you're deterred from applying. Well, now that is now covered in the new law. It wasn't in the old law. Sometimes it was and sometimes it wasn't, and that was the part of the problem. So yes, it's a complete recast of it. Try to associate all, and of course there have been a number of changes, substantive changes as well in the law. But that is the basis for it.
Okay, so the new book covers this Act in detail.
It deals with, the Act itself is a massive thing. It's got 218 sections and I think 29 schedules, which is quite massive. What my book deals with is the employment law aspects of that Act, which are in certain sections, okay? Because the rest of it, dealing with public sector equality and all the rest of it, well, other commentators will write on that and other books, yes. You know, there are 23 chapters. And I think every chapter has got changes in it. I can pick out from one chapter to another. I mean, what I try to do is keep it up to date with new ideas. For example, I did a couple of pages on what I call the volcano effect. Now, all these people who were left stranded in Mallorca or whatever it was, couldn't get back to work. Now, what's their legal position as far as the employer's concerned? Does he have to pay them while they're stuck out in some holiday resort? If he's a monthly paid worker, can he deduct a certain amount for the period of time when they're not being at work? Does the period extended holiday count towards their holiday entitlement? And so there's lots of interesting problems. So this is what I try to do, get new ideas into the book as well. But yes, every chapter's got changes in it. Territorial jurisdiction's another one where you get a person who's British, who's working for a German company out in Thailand, and he's dismissed. Now, you know, does he have a remedy here in Great Britain? This is a sort of, I mean, it's not clear. The law's never clear on this subject. So yes, so what I've done is an extended section on that. And so every chapter, I mean, new regulations on agency workers, on time off work, for study and training, for the paternity leave. Now father can take a share of the mother's maternity leave, and so every chapter's got something new. Do remember one thing. At the moment, last year there were 250,000 applications to employment tribunals for employers' disputes, right? You've got, what, 26 million employees in this country, you've got 3 million employers, you've got 50,000 human resource people, you've got trade unions. All these people have got employment law problems. Now, you know, there's a massive market there, and what you've got to do is reach the market as best as you can. Now, you can't be the same thing to all men, you can't meet everybody's needs, but I try to be as broad as possible so I can get in as many people as possible. And hopefully the sales will show it.